What you need to know about drunk driving charges. A drunk driving arrest is many people's first exposure to the criminal justice system. An arrest is a scary experience, but making sure you know how to navigate the system will impact how your case is resolved. When is a driver drunk? The definition of drunk driving is left up to each state, which decides what a driver's blood alcohol content has to be to operate a motor vehicle safely. In every state, however, that level is set at 0.8%. Many states also have lower levels of permissible blood alcohol content for certain classes of drivers. For example, many states have limits as low as 0.4% for commercial truck drivers, and even lower limits for drivers under the legal drinking age of 21. Many states also have enhanced drunk driving laws, which allow for harsher penalties if your blood alcohol is, for example, double the legal limit. What are the penalties for drunk driving? While every state now considers driving with a blood alcohol C of 0.8% to be driving drunk, penalties for a drunk driving conviction vary widely. However, in nearly all states, a conviction on a charge such as driving under the influence, driving while intoxicated, or operating under the influence includes some combination of jail sentences ranging from a few days to several months, or a few years, fees for court costs and fines, driver's license suspension or revocation, mandatory classes on the dangers of drunk driving, usage of an ignition interlock device to drive, court-ordered alcohol rehabilitation. If you are ever arrested and convicted for driving drunk more than once, each conviction will likely come with worse penalties. The penalties will also increase in severity if you cause an accident with injuries or fatalities. Getting through the drunk driving stop. Even the calmest person can have a tough time maintaining their composure during a drunk driving stop. The flashing lights in your rearview mirror, but it's important to remember that you have the same rights as people in other arrest situations. You have the right to remain silent. You have the right to refuse a search of your car. You have the right to refuse to take roadside sobriety tests, which could include walking a line, reciting the alphabet, breathing into a portable breath testing device. However, if you refuse any of the above requests, it's important to know that police may still arrest you for drunk driving if they have probable cause that you are drunk. Probable cause for the stop. Police will stop you if they have probable cause to believe that you might be intoxicated or under the influence of drugs. The National Highway Traffic Safety Administration has developed a list of things that might indicate that a driver is drunk. Taking a turn too wide, straddling or crossing lane lines, weaving and swerving, striking or almost striking another vehicle, braking too quickly, speeding, running red lights or stop signs. If an officer stops you for an unrelated traffic violation such as speeding, you may end up with a drunk driving charge. This could result from the officer observing the smell of alcohol coming from the car, or on your breath, your slurred speech, or bloodshot eyes, which may also provide probable cause for a drunk driving evaluation. Some states also have laws that allow police to set up roadside checkpoints where they can stop any vehicle. In some cases, those checkpoints may also have judges on hand to sign search warrants to allow vehicle searches. In this situation, you still have the right to refuse to answer questions, but it may lead to an arrest. Once you are arrested, police will likely administer a breathalyzer test at the police station. Every state now has an implied consent law that makes taking the test mandatory. You can refuse to take the test, but that may mean you face an automatic penalty, such as a driver's license suspension. Do you need a lawyer for a DUI? As soon as you have the chance to make a phone call, your first call should be to a lawyer who has experience handling drunk driving cases. You may not realize it at the time, but there may be several options for mounting a defense against the charges, such as a lack of probable cause or police not getting your permission to search your vehicle. The potential penalties for a conviction are too high to simply plead guilty to put it behind you without talking to an attorney first. An attorney will put you in the best position to minimize any damage from an arrest. Speak to an experienced drunk driving attorney today. I hope this helpful and informative, but even common legal matters can become complex and stressful. A qualified drunk driving lawyer can address your particular legal needs, explain the law, and represent you in court. Take the first step now and contact a local drunk driving attorney to discuss your specific legal situation. Imagine if you could pick up the phone, call your attorney, ask your legal questions, and not get a bill. Would you? We don't fix accidents or fix DUIs, but you can get the best representation. Imagine if that situation happened to you. If I could show you a way where you could pick up the phone, call your attorney, and not worry about a bill, would you? See how over 4.5 million people and over 35,000 companies across the US and Canada are now doing. Find out your legal rights. Find out if you're right or wrong, see what to do, and not worry about the bill and sleep better at night. Text Family Legal Help to the number 515-585-11236 or visit www.getfamilylegalhelp.com and download the free legal resource, or call Rod at 515-355-3084 to learn more. You now have the advantage.